Good morning, good evening, good afternoon to everybody. My name is Achille D'Antoni, and today I will be the moderator of this important webinar. As you know, we will be discussing the ITFA dDOC specifications and what UNCITRAL has done in order to, put everything in context. Just to give you a bit of a background, in ITFA DNI Initiative, together with the Terra task force that Andre and I represent, address the needs of electronic transferable records, both technology and regulatory level. Within this, ITFA gets into the dDOC specifications, which are vendor agnostic. This is very important, and has been, inserted into the UNCITRAL, model law, which today Miriam will represent properly. Today webinar will be discussed on a few points. Andre, if you can move to the, everybody can read that. How can trade banks digitize original documents, such as bank guarantees and negotiable instruments, in the most cost-efficient way? How it is enhancing SMEs financing? How can the use of paper originals and postal services be avoided? How can digital documents be recognized as originals and exchanged through banks' own portals to serve MSMEs? What are the dDOC specifications? Is DLT finally helping trade banks? How regulators open digitizing negotiable instrument? As you can see, we have quite a few topics to discuss. And we will be discussing with experts in this field. Andrew, can you please move to the other one? I want to introduce to you Miriam Goldby, who is a professor of shipping, insurance, and commercial law at Queen Mary University. She has been involved since inceptions in creating the model law that, as most of us believe, have been more advanced than technology in itself. So thank you, Miriam, for discussing this, this topic with us today. Then we will be having Andre Casterman. Andre has been the creator of the dDOC specifications, and he will be discussing with us about this particular and very important topic. Then we will have Lars. Lars is, a partner of Inigio and is the most important, original solution that we have, and is complying with the IFAC dDOC specifications. And then we will have Bhavna, who represents the banking system here. In progressing the webinar, I will be asking Bhavna every time one of the speakers will finish her or his intervention to comment about the contents of the speech that we heard. I will at this point move to Miriam to give her view. Thank you, Miriam.
Good afternoon, everyone. And thank you very much, Andre, for inviting me to participate in this event. The topic we're discussing today could not be of higher current significance. The COVID-19 pandemic is only the most recent in a string of developments that have comprehensively demonstrated that continuing to rely on pieces of paper for the purposes of performing and financing cross-border trade transactions is unsustainable. The task allocated to me is to give you a brief introduction to the content of the UNCITRAL model law on electronic transferable records. The model law plus the guide to enactment is 64 pages long. So as I only have 15 minutes, I will focus on the main provisions of the model law. Bhavna has very kindly said if I go over a little bit, she won't shoot me down. So thank you very much, Bhavna. The purpose, actually, Andre, we'll stick to the previous slide. Thank you. The purpose of the model law is to enable the transition from paper documents of title, such as bills of lading, and negotiable instruments such as bills of exchange, to electronic alternatives. And these alternatives need to achieve the same effects in a faster and more efficient way. They also need to be more secure. Why the focus of on these instruments? Well, as you all probably know, they are enablers of international trade. The bill of lading certifies that the contractual goods are in the hands of a third-party carrier who has signed the bill describing them. So the buyer does not simply have to take the seller's word for what the buyer has shipped. And the carrier has also promised, by means of this document, to deliver them. Bills of exchange and promissory notes are credit instruments which certify the debtor's promise to pay a named amount. Both documents of title and negotiable instruments give the person holding the document a claim against the promisor and the right to demand performance when it falls due. Thus, possessing the documents is key to claiming performance of the obligation. This means that it is important to identify both a functional equivalent to the document as an embodiment of the performance obligation and a functional equivalent to possession of it. So these are the two things that the model law was mainly trying to deal with. So next slide, please, Andre. Documents of title and negotiable instruments have been in use for many centuries. And with this first slide, my intention was to remind everybody of why they have been such a success story, in spite of the shortcomings that have come to light in modern times. We use documents of title for two main reasons. First, we have a tendency to trust signed pieces of paper, evidencing certain facts. And secondly, we use them because they achieve desired legal outcomes thanks to widespread recognition of the effects of their issue, their transfer, and their surrender or presentation. In the case of the bill of lading, the facts in question are facts about the goods, who shipped them, where, what their description, quantity, and condition was at the time of shipment, and where the carrier has undertaken to deliver them. These facts and undertakings are attested by the carrier as the signatory, the carrier being a third party to the contract of sale, and who can in theory be trusted to be truthful. Legal recognition of the effects of issue, transfer, and surrender means that the lawful holder of the bill may exercise contractual rights against the carrier and possessory rights vis-à-vis the goods, which may amount to general or special property in the goods. This makes authenticated information on paper reliable. However, information recorded and authenticated on paper is limited in terms of its functionality, in the sense that it is contained in a silo. So communicating the information in its authenticated and therefore reliable form requires moving that piece of paper. And reproducing the information requires rekeying, which is resource intensive and prone to errors. Now, both of these are key considerations in international trade. They are key considerations because a large number of different stakeholders will require access to the information about the goods in order to achieve the successful movement of the goods from A to B. And they are also very relevant in trade finance, where similar data elements are required to appear in a large variety of different documents. So the same information needs to be rekeyed multiple times. Thus, documents of title and negotiable instruments work because they achieve desired legal outcomes as between contractual parties and because parties trust them. These two things are linked, and electronic alternatives need to achieve both of these things in order to substitute their paper counterparts. Next slide, Andre. Let's start by discussing desired legal outcomes. What are they? I have set them out in this slide. So first, the transferee obtains a reliable record that a performance obligation exists and an assurance that performance is due to it. Because if it's holding the paper, then performance of this obligation recorded in the paper is due to it. As a consequence of this, the transferee can exercise rights against the promissor. So essentially, the transfer of a piece of paper makes the transferee the promisee. And the transferee can show it is the promisee by showing that it is in possession of the document and the document's holder. When it comes to the bill of lading, the transferee does not just obtain rights against the carrier, but also over the goods described in the bill of lading. So how can we ensure that the same legal outcomes can be achieved with electronic data? And that's in the next slide. Now, you do so by basically recognizing the ability of electronic alternatives to achieve these outcomes, provided they comply with certain requirements. So you take the legislative route. Now, it's important to bear in mind that taking the legislative route requires one to make certain choices. And bearing in mind that we are talking about enablers of cross-border trade, a uniform solution applicable across jurisdictions is desirable. And this is where UNCITRAL comes in. UNCITRAL works on a consensus basis and therefore was in search of a solution acceptable to all of its member states. To produce legislation enabling electronic data to achieve the same legal effects as paper documents, UNCITRAL had these two options, which I've put on this slide. Option one envisages spelling out the outcomes themselves and then setting out the requirements that electronic systems would have to satisfy in order to achieve these outcomes reliably. However, this would have required member states to agree on the outcomes and ensure that those agreed outcomes were consistent and compatible with those already laid down in their internal laws. So this option was not the best one for UNCITRAL. UNCITRAL chose option two. So you leave the existing internal laws on outcomes untouched, and you simply spell out what constitutes the electronic functional equivalent of the paper form and of physical possession. So this approach may not be ideal as it is still conceptually anchored to an extent in the paper medium, but it has the merit of minimizing grounds of disagreement among the different member state delegations and ensuring that business people are still transacting on the basis of familiar outcomes, which they already know and understand. So in other words, UNCITRAL was aiming to change as little as possible. So next slide. So this brings me to the model law and how it achieves equivalence between paper and electronic documents of title. There are three key provisions that do this, and the rest of my presentation is basically intended to cover these three provisions. First, Article 10. This sets out what requirements an electronic record needs to satisfy in order to be deemed transferable. Aside from noting that it has to have at least the same content as its paper counterpart, the article requires three things, and you will see them in paragraph 1b. First, identification of the record as transferable. Second, subjection of the record to control. And third, integrity, defined in paragraph 2. This article therefore introduces the need to singularize the record by giving it an identity and making it subject to control, that is, ascribable to a specific person who would have the rights of the possessor if this were a paper document. Next slide. Thank you. So in this slide, I explained how these things are ensured. The first requirement as to content should be read in light of Article 6. So the fact that Article 10 is requiring the same content to appear in the electronic counterpart does not mean that additional content is precluded. Indeed, additional content can enhance the functionality of the data, and also in the case of the bill of lading data, permit the information about the cargo to be kept up to date, which can speed up the execution of steps in the supply chain, as well as performance of accessory contracts, for example, cargo insurance contracts. Second, Article 10(1)(b)(1) should be read as requiring a mechanism to ascribe a unique identity to the record, so that no matter how many copies of the data making up the record exist, it remains representative of a single obligation. Then the third thing required is the identified record must be capable of being associated with a person, termed the person in control, in the same way as a paper document would be associated with its possessor. And finally, in order to ensure integrity, any changes to the record must be identifiable as such. Then moving on to the next slide, which shows you Article 11. Article 11 is the second key provision, and its purpose is to establish a functional equivalent of possession. The equivalent concept selected is that of control. In order to be the equivalent of factual possession, control must be exclusive, as you can see in this article. Although the guide to enactment does make clear that there's nothing to preclude joint control, because in the paper world, there's nothing to preclude joint possession. Another requirement that control must satisfy is that there must be a reliable method of identifying the person in control, as there would be if a person were in possession of a paper document. And then paragraph 2 provides that transferring control has equivalent effects to transferring possession. And moving on to the next slide. So what Article 11 is requiring is the ability to establish reliably to whom the performance is due. This means that on designing the system and its underlying terms of use, what constitutes a transfer of control needs to be determined. That is, what act is equivalent to handing over a paper document with or without endorsement. Article 15 on endorsement would also need to be taken into account in designing the transfer mechanism. For example, acts constituting a transfer may include clicking an endorse and transfer button available only to the person logged in as the person in control, clicking an accept button available only to the person logged in as the designated transferee, an update on the system of what Article 10 terms the electronic transferable record, that is data relating to the performance obligation plus data relating to the person to whom it is due. So once these actions have been taken, endorse and transfer, accept, and an update of the record on the system, then you have the equivalence of endorsing and delivering a paper document of title or a paper negotiable instrument. So moving on to slide 9. This is the final of the key provisions, the 3 key provisions, which I promised to talk about. What this sets out is a general reliability standard. Now, if you noticed in Article 10 and 11, both of them require that a reliable method is used to singularize the record and to confer control over it. And accordingly, this provision, this article, lists a number of circumstances to which regard may be had when establishing whether the method used for the purposes of recording and transferring rights is reliable. While the implication is that the consequence of not adopting a reliable method is that one would not be considered at law to have control, and while this may be viewed as introducing an element of uncertainty for holders of electronic transferable records, it is worthwhile to bear in mind that reliable does not mean the same as infallible, And the article is intended more than anything to provide a framework for careful and prudent system design, so as to ensure that electronic alternatives enjoy the same widespread acceptance as their universally trusted paper counterparts. So essentially, the idea here is to engender trust in these records by looking at the system whereby control is granted. The uncertainty is mitigated by subarticle B, according to which, if the method in question is proven in fact to have fulfilled the function by itself or together with further evidence, the reliability standard is deemed to have been met in the particular case. So this is intended to reduce the opportunity for frivolous litigation. And then moving on to the next slide. As you will see from this slide, reliability is determined by reference to the control environment. So the environment surrounding the design and use of the system. A control environment is made up of contextual factors. All these factors listed here are contextual factors, namely the people managing and using the system, the technological and human processes for managing and using the system, and the technology used to run the system. So when assessing reliability, these are the things that you would be looking at. And then my final slide. So the model law so far has only been adopted by one jurisdiction, namely Bahrain. But the underlying ideas and principles are likely to be of great significance in the various legal reform initiatives that we are likely to see happening across the world in order to address the paper problem in international trade. All domestic laws are different, and careful impact assessments will need to take place at the national level before adoption of these reforms can take place. However, my prediction is that we will see a great deal of activity in this space over the next few years. For example, as I've shown on this slide, the Law Commission of England and Wales is currently working on a digital assets project, which includes within its ambit digital documents of title and negotiable instruments. As you can see from the website, I've put a screenshot on this slide. As was the case for the model law, the concept of possession and the extent to which it can extend to the virtual world is central to this project. I will stop here. I think I've taken about 18 minutes, so thank you, Bhavna, for not shutting me down. And yeah, I'm happy to take any questions the audience might have.
Thank you, Miriam. Just, first of all, I mean, Bhavna, have you any question for Miriam? Bhavna, you are on mute.
She might have had to step away, Akile, I'm not sure.
No problem, no problem.
No, I'm here, I'm here. Sorry, I was on mute. Sorry about that. Can you hear me now?
Yeah, absolutely. Thank you.
Okay, fantastic. So I think what I'm going to say is that I want to say thank you to Miriam, first of all, for such an intellectually curious content that she's been able to share with us. So thank you. I think my comments and my feedback would be, as a banker, right, we are here to serve our clients. We have to make their journey faster, quicker, and cheaper if possible. So, when you put yourselves in the shoes of an SME, and you're going to see me mention the word MSME, SMEs, and COVID a few times during the presentation today, because clients are really at the heart of all our efforts. The need for liquidity often trumps the need for risk mitigation, but trust is still an important factor that companies rely on banks to provide in the equation, especially given, what we have seen, what's happened around COVID, and the volatility as a result of that in the market. And I think it is the digital interventions like this that is really paving the way for solutions that provide that same assurance of a traditional trade, the paper documents, Miriam, that you mentioned about, but without the hassle of paper. making that client journey faster and quicker on it. And the pace of change in solution has to be supported by change in law. So, you know, whilst we have all these amazing fintechs, you know, we're going to talk about some of them in today's session out there, we need that to be supported by change in law, because that in itself is not enough. So I think the change in law and what you talked about, the adoption of some of these digital transferable law concepts, is a really important development that has to take place at the same pace as some of the technologies coming in on there. And for me as a banker, you know, we sit in UK, you know, Brexit is on horizon. We're really looking forward to getting some alleviation through these mechanisms to help and support our clients. So I think for me, it's the two go hand in hand.
Absolutely. Thank you, Bhavna. Before we move to the next speech, I'm seeing that in the Q&A box, we are having a couple of questions so far. I would ask to be patient and to go to the Q&A sections at the end of each session. So right after Bhavna, thank you. Who is next one? Is Andrea, I believe, right?
Yes, indeed. Thank you, Achille. Indeed, we have a great model law here, a framework for countries to adopt at the legal level, a regulatory level. Let's now look at the underlying technology, because I think the last slide that Miriam has shown is critical, whereby the regulator already, I mean, all slides were critical, of course, Miriam, but the last one is, I think, critical in terms of what is happening in the industry and also outside of trade with digital assets. Indeed, when you're looking at what is happening in payments, in securities services, more and more asset and asset ownership is fully digital. And certainly when it comes to digital assets, cryptocurrencies, which central banks are seriously looking at. So I think on the infrastructure level, it is important to consider that the time that we have enjoyed since until now, whereby you have proprietary platforms trying to attract as many participants to digitize a particular process, that time has to evolve to a time where interoperability of those digital assets is enabled through technology, in the same way as paper can be transferred from one party to the other without those two parties signing to a particular provider of paper. So definitely this trend we see in the market on the digital asset side is critical, because it will enable indeed various types of digital assets to be possessed fully electronically, to be transferred fully electronically. And this is where some of the recent technologies like electronic signatures and other technologies like distributed ledger technology should help and already help in some industries. So let's look at how this can be achieved in a vendor agnostic way. And this is where ITFA, through the DNI initiative that Achille was introducing at the beginning, through that initiative, working with different technologists and bankers, we have come up with our own framework, technology-centric framework, to enable basically the industry to move to technology in a way that is as easy as the use of paper today. Whereby indeed anyone can buy paper from any paper provider, anyone can hand over paper to any other party without those two parties being using the same underlying infrastructure. So that's really the principle of those digital document specifications, is that the document that is being digitized through any vendor, and we're going to talk about one solution later, should be open to any type of document format, whether the format of the document is according to an industry standard or not. and any type of also document type, whether we're talking about the guarantee, a bill of exchange, a bill of lading, indeed. And this openness is not just about the document type and the format, but also any type of financial institution and any type of client of the financial institution, a corporate, an SME, an SMEs, as Bhavna said, very important, or a counterparting FI like a correspondent bank. It's also important that this technology is open to third-party trade platforms, because although those platforms, in my view, have not been sufficiently interoperable for commercial reasons, they are very closed, but they also are critical because they offer value-added services. Looking at bill of lading platforms, they go far beyond the digitization of a particular document. They connect various counterparties that have to work on a common document like the bill of lading. So the openness to not only FIs and their clients, but to those third-party platforms are important as well. And that's also a principle we took into account. With the mindset that we want to be pragmatic and respect the existing investments in technology, in communication channels that the banks and their clients and platforms have made, it is important for those technologies complying with the dDOC specifications to be compatible with the existing communication channels, and also to support structured data within the document, or free text data as well. So as you can see, those requirements are there to ensure we provide the same benefits as what paper provides today. No need to sign up to a single technology platform, and that is full compatibility with the existing technologies that banks use today. So of course we need to take into account what technology offers today on top of paper. And this is where, recognizing the power of distributed ledger, we have added into those principles and specifications the need for a tracking system through a public register. And the public is important. It's a public register that anyone can access. But of course, as we are in financial services, that register, as you would expect, is compliant with the data privacy laws. That means that it would not contain business data, because that business data should remain within the bank's own infrastructure. So basically, we want those specifications to enable banks to benefit from what they enjoy today with paper, but also freely transferable and accessible, because paper is accessible to anyone. But also we want the banks to benefit from the recent technological developments, such as electronic signatures, DLT, which we're using here in a hybrid way. So I will not go into the details of all those technologies, because that's not the goal, but it's important to consider how we have designed those specifications based on what technology allows to do today. So the three building blocks that we have considered here are made of a digital container, which is a file, an electronic file that is designed using Ricardian contracts and JSON technology. It is secured with electronic signatures and stamps, timestamps as well. And it is tracked through a shared public DLT, which is acting as the digital notary. That's those three building blocks are actually enabling the transfer, the technical transfer of an authenticated data set, whether you want to structure that data set in a proprietary format or in a free text format or in one of those industry standards that the industry may want to develop through one of the associations like ICC or others on the logistics side. So these are the three building blocks. And as you will see on this next slide, it is important for those three building blocks. So as I said, digital container, electronic signatures and seals, and digital notary, that they are compatible with the existing infrastructure. Though those dDOC specifications is not about designing yet another central platform that would aim to connect all the banks and all the corporate clients of the banks, because that will never happen. There's no way the SME clients of large banks would, or smaller banks would want to sign up to a third-party platform. They want to get this technology through their own banks, and they want to get this technology through the portals that the banks are using today. So the compatibility with the existing infrastructure is critical, whether we're talking about the use of electronic banking capabilities, or SWIFT capabilities, EBIX, which is a file transfer capability quite standardized in Europe. And those electronic documents complying with the dDOC specifications must also be compatible with the existing trade applications that the banks are using. And those applications could be internal, like the front to back office processes of banks, or they could be external if a bank decides to use the one or the other external platform for managing bills of lading, for instance. Those platforms are very well known, like Bolero, SDocs, and others, or other types of documents in the logistics space. So in essence, what those specifications are bringing to banks is a technology framework to define how a file can describe a bill of exchange, a guarantee, or a promissory note, which is our main focus here. It could also be applicable to bills of lading, but let's start with what we believe is the low-hanging fruit in terms of digitizing those trade documents, guarantees, bills of exchange, and promissory notes can be digitized using those technologies, and while still being very compatible with the existing front to back processes, back office processes, as well as channels. Those the digital container is actually represented as an electronic file. And maybe you have read one of my recent blogs on this matter. I mean, any application can handle a file these days. Any e-banking application, any back office application, any channel, including SWIFT with FileAct, for instance, can handle application. So what the digital container offers here is a file representing the original, not a copy of the original, but the original. And that file is secured with electronic signatures. And of course, this is, I leave that to the experts to explain how far that goes in terms of securing the file. But basically, by transferring the file and updating the distributed ledger, which is tracking the life cycle of the file, this framework delivers all of the needed attributes to manage original documents and to prove the originality of the document at any point in time. So those are the specifications to basically secure the files. And once the technology has created the file, it can be updated to in case of transfer of ownership, in case of change of content. And we are still talking about exchanging a file as you would exchange a piece of paper today. Of course, the critical need here is to upgrade the law in order to recognize possession and transfer of possession in an electronic way. But the technology layer supports it as it is today. The challenge indeed is to implement UNCITRAL on top of this within the different countries, as this is being worked on through the Law Commission, as we heard from Miriam. So in addition to the file, which contains all of the business data and which is secured, as we have seen, We have also the distributed ledger technology, which is used here as a public ledger that is therefore accessible by anyone. But if you don't have the keys to understand what is stored there, the data will not mean anything to you. So by accessing the distributed ledger in order to track the life cycle of the document, the original document, and with the right keys, you can check indeed that the document you own is still the last one, the last version, and is still yourself as the owner of that document. So this is also compatible with the data privacy laws that banks need to adhere to, which means that banks control the business data which is stored within the file, and that file does not leave their back office until such time that it needs to, for transferring or for delivering to the client, for instance. And the distributed ledger does not contain any business data, so that we have the best of both worlds, a secured file with all the business detail and a public distributed ledger to provide the tracking of the document itself. So similarly, as I said, with regards to the front to back office processes and the channel, the whole technology, not only the file, but the DLT, it can be integrated within those existing systems so that existing processes can be incrementally upgraded to support paper digitization, like scanned copies, in parallel with digital assets, such as what we want to do here for guarantees, bills of exchange, and promissory notes using those dDOC specifications. And an example of this integration is shown here on the next slide, whereby you see the internal front to back office infrastructure of a bank being upgraded with one vendor that is today compatible with those dDOC specifications, and this is a NIGU with a trace original product. So the file itself containing the guarantee or the bill of exchange or the promissory note is integrated within the e-banking, within the trade finance application, within the middleware and the network interface, because this is just a file, secured. Separately from the bank internal infrastructure, you have a public DLT at the top, which is the tracking system to check and to demonstrate ownership, originality, and full life cycle of the digital asset. It could be indeed a negotiable instrument. And if you're adding on top of this additional capabilities, such as a trade document compliance and processing system like TradeStream, those systems can also process the information that they're getting as with an electronic feed, such as a trace original file. And in that case, of course, the OCR capability of such tool is not needed, but the checking of the content of the document is of course critical. So this is just to demonstrate how the existing infrastructure of a bank, complemented with the different channels you see on the right, is completely reused. And what we are digitizing is really the document through a secured file. And the first vendor we found that is able to achieve this is Enigio. And of course, the dDOC specifications are open to any vendor. Today, in addition to Enigio, China Systems, as a trade finance application, has already demonstrated in Q2 their compatibility with those specifications. And over time, we want indeed to certify more and more vendors, whether we're talking about trade document processing systems or back office applications or middlewares or competitors to Enigio itself. We want to make sure that we apply those concepts to as many vendors as possible going forward. We believe this is the right approach to ensure interoperability between FIs and their clients, not forcing the clients of the banks to sign up to a third-party platform, while still enabling third-party platforms to exist and to be more interoperable today, thanks to that type of technology. So third-party platforms are critical, but I believe they can benefit also from those specifications and that kind of technology in order to open up and avoid being closed as they are today, whether we talk about bill of lading or other types of trade documentation platforms. Achille,
Thank you
over
very
to
much.
you.
Andre, thank you very much. Before we move to Lars, I wanted to know some comments, if any, from Bhavna.
I guess I think I would only say this in essence of time is to if there was a, I would say, a summary of what Andre has said, is why it is interesting for us as a bank is because, you know, like I mentioned, we are here to serve our clients. It is really very overwhelming if you expect our clients, you know, we talked about SMEs, MSMEs, to kind of hook up with different platforms that are popping left, right, and center. It's impossible. They have no time for it. They have no resources. They have no money to do that. So what is the responsibility of a bank? How can we then enable still a frictionless, a paperless experience for our clients? And I think what Andre is kind of conveyed through his presentation is to say, you know, as bankers, we are bringing some of this technology into our systems so that then, you know, our clients can benefit from it. So they become the recipient of that benefit rather than having to, you know, cross that bridge or that make that journey themselves for it. And I think that's the key message I imagine what Andre was trying to say. And, you know, Lloyd's is, and I'm going to talk a little bit during my session as well, how we have gone about it.
Andre? I guess that was the reason, right?
Yes, definitely. We'll come on back on that when Bhavna will speak about Lloyd's implementation.
If I may humbly add, you know, in this case, the bank becomes an enabler of technology for the clients, particularly for the small and very small, medium enterprises. Lars, to you now,
Exactly.
on the stage.
Thank you. And hopefully I can contribute from a practical side and praise the Commission on International Trade Law at the UN for doing a fantastic job. And I want to point out that this fantastic job has, in many cases, been the inspiration for current legislation and is the inspiration for the coming proposal or the current proposals for legal changes in many countries. The impact of the model law is much greater than we think, because we have a tendency of looking what is not there. But if you look backwards from when the model law was first written, it's been kind of a source of inspiration. What the model law for electronically transferable records did was that it defined the requirements for something that did not exist, because technicians had not kind of figured out what to create. We had created a lot of platforms where we had membership platforms, which was really good, but it wasn't open for everyone. And then UNCITRAL comes up with the idea of, okay, let's change, but change as little as possible so that it can be adopted. And this is a marvelous idea. And the beauty of a negotiable instrument is that it is an independent and irrevocable payment undertaking that is separated from the underlying transaction. And as a banker, we don't really care about the goods and the services. We just want to get paid for whatever loan we were given. So we don't want to get caught up in a discussion about whether it was a car or a lorry that was delivered. We just want to be paid for our loan. The other thing is that it has a well-defined chain of rights and endorsability. So you actually know that you can work with recourse. And this is a nice thing, because all of a sudden you can work with moral hazard in a very neat way as a banker. And all of a sudden you can do wonderful things like credit insurance and possibly even put a val if you like the credit risk. And this is a globally accepted instrument. The Geneva Convention of 1931 kind of opened up a world of trade, a very, very important year for global trade. And it reduced cost, because all of a sudden we had legal certainty in international trade. Although it's not been ratified by all countries, most countries with civil law have ratified it. So if you understand what a digital negotiable instrument must be subject to, and you look at the model law, it defines singularity, the ability to distinguish a copy from an original. So that's an inspiration. To define the exclusive controller and define the holder. You have to make it presentable to a court, but because although a bill of exchange is a secure document, you might have a dispute. And so it has to be presentable, and it has to be transferable, it has to be enforceable, and you have to be able to sign it electronically. All these things, they are defined in the model law in a very, very neat way. So the impressive thing is that the lawyers and the legal scholars defined what technology people had to deliver. So when we sat down to address this issue, I wasn't too familiar with model law and the electronically transferable records legislation. But what we had was ADAS, the European regulation on electronic signatures and trust services. And when you look at that legislation, and you find basically identical wording from the model law in the European regulation. So obviously, model law has been an inspiration, but we have, so the signature acts and the acts defining electronic transferable documents or electronic transfer has been really the source of information, inspiration has been the model law. For instance, in America, the UITA, which is the Uniform Electronic Transactions Act, they allow for electronic notes, which is a negotiable instrument in essence, chattel papers. In New York and Illinois, in the comments, the model law is actually referred to as the inspiration because they also allow for negotiable instruments. Now that has not been tested in court yet, but the wording is there. So for us at Inigo, when we started working with this, we had ADAS as one component. We were looking at the Bill of Exchange Act and the legislation around negotiable instruments. But on top of that, we were just looking at the legislation governing banking secrecy, data protection, and also how to handle anti-money laundering legislation and sanctions legislation. If you put all those ingredients into one pot and you try to define an electronic product that will cater for all these requirements, you end up with an electronic document where you say that you can distinguish an original from a copy, it's transferable, etc., etc. and it has to be fraud safe. So if we turn to the next slide and we look at how simple can you make it? So what you need to do is you have to create a document that is unique, the singularity aspect of it. And you have to write content into that document. And then once you've written that content, you will actually have someone to make a promise. And in that document, you also have to identify yourself, because from a legal perspective, you need to identify both parties. So the second thing is that you need to add text to the document. And this text can either be a condition or a signature. It really doesn't matter. But nothing that is previously written can be altered, because otherwise we don't cater with the requirements of most Bill of Exchange Acts globally. The document has to be transferable, and it has to be endorsable. So again, when you do make a transfer, you have to be able to put in a signature into the document, because it's not likely that the UK, for instance, will take away the requirement to sign the Bill of Exchange when legislation comes to a change. And the last thing is that you have to be able to invalidate the document, because you want to be sure that a Bill of Exchange at some point becomes null and void. It doesn't have to be more complicated than this from a user perspective. Back behind this, I can promise you there is some advanced technology and some really a lot of thinking. But from a user perspective, this is what you should see. Should we push to the next slide? So what is so unique about what we've done? Well, if you on the left-hand side, you have an axis where we could call it possession. How do you prove possession? And if you look, and on the right-hand side, you can talk about information integrity. Today, we scan a lot of documents to process them. And the problem with scanning is that if the document, the original, changes, all of a sudden you have a fork in truth. The scanned copy says something, and the original document says something else, something different. But scanning has so far been the best way of making processes more efficient. Some documents you can make as what we in Scandinavia call an electronic document, which means that you can lock the content to the signature so that the promise can be verified because the signature is linked to the content of the document, but it cannot be linked into a single document. The requirement of singularity is not there. And that's okay for any type of promise which will not change over time. But then until now, we've been caught to paper. We've had to use paper because paper has been the only source of singularity. And that's why basically all negotiable instruments are still paper-based. So our proposal is to make a more secure document electronically, which is fraud safe, because that is a problem with paper, that you have multiple spending, double spending, and fraud. So presenting a fraud safe, possessable electronic document, that must, in our view, that must be the future. And the neat thing with making it a document is that it can be both processed in straight-through processing. You can apply artificial intelligence to the data because it's easy to capture. But you can also manage this if you're a small SME manually. Because if you have a computer and you have a signature service, you should be able to own and to trade a valuable digital asset. So what our hope is that this technology will enable small companies to, instead of just relying on an invoice to be paid, that they can actually use a bill of exchange as an acceptance on a single transaction. And they could actually sell this bill of exchange to the bank and then create working capital. And for the buyer, if the bill of exchange is on 30 days or on 90 days, the seller can still provide payment terms that are really attractive. And you could actually do this in straight through processing. So we believe this is the gateway to SME and micro SME financing for many banks. And this is a significant need in Europe, in the US, and in Asia. I'm going to stop there because we need to have time for questions.
Thank you, Lars. Thank you, Lars. Bhavna, any comment before you start? Last but not least, obviously. Bhavna, you are on mute.
Yes, I put myself on mute. Well, listen, I'm going to go into my presentation. So I would, if that's okay with you, I just want to know, Akile, though, how much time do I have so that I can pace myself?
Yeah, 10, 15 minutes now. And
okay, perfect.
We will be asking just to beg our pardon when in case we do go over the time.
Okay, no problem. I'll try to be efficient. Okay, well, I think I want to just summarize what we have covered till now on the session. So, you know, we started about Miriam's presentation on the changes in the law that we are looking and some of the principles we may embrace as we go about it. So, you know, very helpful, you know, start of the session there. Then we talked a little about, you know, the dDOC specifications that Andre presented, whereby, you know, what if we decided to do that, you know, what are some of those criteria that need to be met for adoption to take place? And then you had Lars talk about, you know, as a technology provider or a fintech, you know, how do we bring all this to fruition? And I think at the sort of end of this chain, it's really an important role that we as banks play, because at the end of receiving end of collective efforts, you know, be it the changes in the law, the specifications on the documentation side, the fintechs, banks, you know, you have the client who it needs to make sense for the client. From a client needs perspective, you know, their needs are still pretty much the same. They want liquidity, they want risk mitigation. So, you know, that risk mitigation and liquidity can come in different guises, different forms. And I think as our bankers, we have to make that access, that need addressable or achievable in a sort of a seamless, frictionless way. So, you know, when we are thinking about, you know, within the banking industry, some of the key considerations that we have is, you know, we want to start small, right? Why do we want to start small? Because, you know, sometimes the technologies are still in their infancy. They're not tested. So we don't want to boil the ocean and spend a lot of investment dollars towards it. So we engage on what we call the proof of concept. It allows us to get familiar with the technology and then try to see if we want to, you know, expand it beyond that. If we can avoid a back office integration, that would be ideal. We understand that maybe not always possible, but that would be on our list of, you know, considerations that we would have. You know, we don't have an unlimited budget. So, you know, the cost associated with it is important. And a lot of times, you know, we have these fintechs who are looking for that adoption, who are looking for that scale, willing to offer free proof of concepts. But even though they may provide it free, you still have costs associated with technical integration, and organizing and mobilizes the bank, internal organization in the bank. And the last thing is that if we want to go down this route, we were looking for scale. We're looking for use cases that will bring us the biggest upside and client impact. And I'll talk through all these things as I walk you through some of the examples we have experimented with at Lloyd's. Then, like I said, there is also the very important question about clients we are looking to serve. So how do we make that experience seamless, take out the friction, take out the cost of joining a new platform? And let's face it, as I mentioned earlier in the session, we're talking about clients at the smaller end of the turnover, the MSMEs, the SMEs, who do not have the dedicated teams to indulge into technical paperwork, even to entertain any sort of vendor onboarding. So we're not making a platform sale to them. What we are saying to them is we will enable our rails so that that experience and that user journey can be as easy as possible on there. So allowing them to then take the leap towards digitalization on there. And I think some of the work we have done in collaboration with ITFA through their DNI initiative is really all about that. We're integrating the tech with the bank, using the bank rails and achieving that client connectivity through that. We experimented on electronic signature, and we have got a proof of concept running around guarantees that we will talk a little bit more about. And again, the ethos or the sentiment behind that is that we want to make that journey, we want to make that leap of leap towards digitalization for our clients a lot more easier, so the bank takes all the pain on it. Now, when we looked at the use cases, we were very clear what we wanted to target, that we wanted to target documentary trade instruments. Why? Because people who have been in the trade business, that we know that it is riddled with paper shifting from point A to B and changing hands with so many parties in the equation. But what we wanted to avoid was the complexity associated with a letter of credit, where you have to engage with the shipping company, the insurance company, the client, the banks, etc. So you have many parties to take into consideration, as against guarantees or negotiable instruments, where the number of parties is finite, a very small number, and actually the underlying instrument is also very simple. And what I mean by that is, beyond the issuance of those documents, you have lesser of the life cycle events, like the amendments, like the negotiation, etc. So we decided to pilot around guarantees with Enigio's Trace Original, which allows us to convert some of those documents into sort of digital documents, secure the files, which offer the highest levels of control in terms of document ownership and lifecycle traceability. Tracking the document lifecycle, as you have heard Andre say, is the role of a DLT, right? But it sits outside the bank's sort of back office and the middleware that the diagram that he was showing there. So we have embraced that, and we have applied that in our use case for digitizing guarantees. And I think what I would say is that the use of that is going to be so handy right now, with as UK prepares for Brexit. We are expecting the demand for these guarantees to increase. So the work that we are doing with HMRC around this is really going to hopefully hold us in good stead. We are at a stage 1 in terms of the POC we're running. We're looking. We're also working in parallel with ICC to bring about changes in law. Miriam mentioned a little bit about it. Part of the working group that is working with the UK Law Commission to bring about changes in the law as well. So if you just move to slide number 2. Yeah. So in the previous slide, we talked about, due to the advanced design of Inigio's Trace Original, it makes the original documents portable between all participants to the documentary flow and systems involved. And this actually removes the need for them to be plugged to a common trade document processing platform. Now, whilst we're talking this from a sort of a bank and a customer perspective, there is also an important leg to the transaction. And, I want to bring into it the role of SWIFT. SWIFT has an equally important role here to play. And, they can actually use the rails, the channels that already exist between banks to transfer and digitize the presentation of the document. So this particular slide talks about that connectivity you can have between the client and the bank, and then the bank and to bank. So you get the best of both worlds from a sort of a value proposition perspective. And at Lloyd's, actually, we have run and experimented with both. So we have successfully achieved a POC on the File Act, under the SWIFT File Act, to kind of check the presentation of documents between bank to bank. And also, on the Inigio side, we have done the same from the connectivity of digitizing documents internally around guarantee on there. So I think trade banks, I feel like, will benefit from the File Act and a combination of the Trace Original solution, whilst continuing to use their existing channel and front to back office systems in place. And the combined use of SWIFT and Inigio fills this gap in trade documentation portability. So I think that's really what this particular slide is saying, and I can assure you through our own experience that it works. And it's like I said, it's a POC, it's experimentation. We haven't really built it to scale. We haven't really commercialized it because at the moment, we're just trying to see, which corridors will work with us, which banks are willing to come onto this platform as well. Because I think all these systems and solutions cannot just work sitting on islands. There has to be interoperability. There has to be adoption for this to really become an ecosystem that we can really deliver, like a one connection. The client connects once into the bank, and the bank then connects to many. So it's a one-to-many. But for that to happen, there has to be interoperability and adoption. And the last slide here is, you've seen that Miriam used that as well. And I just wanted to just briefly touch upon this because I am part of that working group as well, that through this exercise, we are providing the business case for a change in law to digitize bills of lading, bills of exchange, promissory notes. And this piece of work is being undertaken between ICC, DCMS, which stands for Department of Digital, Cultural Media, and Law Commission, with a possible replication across other jurisdictions. And I think we decided to work on English law because we know English law is very transportable across other jurisdictions. But we are hoping that some of this work is going to provide the necessary leadership for other jurisdictions to embrace change. Even at one point, I thought, like, why there isn't a law out there that is available as a golden copy or golden standard and everyone just adopts it. And the issue is that adopting a law like that, it's an entirety, may have an impact on the other aspects of e-commerce, and hence it is important that we look at the aspects that really add value and relevance. So this working group is looking to provide a recommendation in early next year. We are really hoping that we will be able to bring about some positive recommendation and changes to the law by at least spring next year. And again, why are we doing all this? The UK government is asking us, what does it really mean for us as a country? What does it mean for us as GDP? What impact is it going to have? What is the market growth opportunity that this law change can bring? And that's why, you've heard me talk about MSMEs and SMEs, because this is a particular sector where, 90% of UK productivity is lost. So whatever solutions we, you know, come up with, we bring to the table have to be applicable and should have relevance to this particular sector. We have to make that journey and their journey a lot more easier, so that they can, you know, go about their business in a sort of a smooth and hopefully a digital way. And I think with that, I'm going to rest my case, and I'll stop and would be happy to take any questions from the audience. Thank you for having me.
Bhavna, thank you. Thank you very much for your intervention. I would move to the questions and answers at this point, just to know whether there are some unanswered questions, because we have seen moving back and forth some questions that then were addressed, so therefore were deleted. If there are no other questions, I would move to the wrap-up. First of all, thank you very much for having joined us today. Very interesting interventions, and more importantly, to see, you know, at least on from my point of view, to see convergence of technology and legal, and obviously also, as Bhavna has expressed, I mean, the interest of the banking to go through this line if scalable and obviously say customer friendly. The three layers of value that today we have considered is a new payment undertaking instruments, digital original documents, transport mechanism, and more importantly, as you must have heard several times during the various interventions, security and trust is that they are the two, say, most important words that we have to bear in mind when we in this industry develop something that can be used by our clients or by our suppliers. So in ending up the sections, I want to thank you everybody, Miriam, Lars, and Bhavna and Andre, for having organized such a great event, and to the next. Thank you.
Thank you.
Bye.
Thank you. Thank you, everyone. Bye-bye.
Thanks, everyone. Bye-bye.
Bye.